Boom. Hey, folks, how's everyone doing? It's been a while since we had a Monday show. We've had shows on Mondays, but it's been a while since we actually had a Monday show. So today we've got a Monday show. um, we got a few things to cover. I don't know how long it's going to be. I don't know if it's too short, we can add some more stuff. If it's too long, we can just go long. That's how we do it. So, yeah, we're going to start off with a goal, and the goal is going to be, as is kind of traditional, we are going to start off with a goal for Runkle Have a Drink. Because, yeah, it's been a long week, and it's only Monday. Boom quietly, please. My dog is sleeping on my lap. Oh, are you guys? I see somebody saying echo. Or are you guys getting an echo? You were great on Lawyer You Know. I really enjoy having a chat with Lawyer You Know because Lawyer You Know is really, really bright. He's really incisive. He asks great questions, and he's just a great guy. Like he's just yeah. So it was a great discussion. We talked about gun issues in the whole Kelsey Fitzsimmons trial. I didn't think the Kelsey Fitzsimmons trial was going to be such a gun heavy file. Like I just didn't, because at the end of the day, I was like, all right, so this is going to be a file. I mean, I thought it was largely going to be like he said, she said, right? And there's lots of trials that are he said, she said, right? And I mean, at the end of the day, it just comes down to who testifies better, who gets busted on cross-examination, these kinds of things. But a whole lot of it came down to issues of the firearm and like how the firearm operates and firearm forensics. And I was like, okay, wow, that is a thing. So yeah, it's a whole epic thing. Now, today we've got a bunch of interesting stuff. We have some stuff for taking care of Maya. And I warn you guys, the taking care of Maya stuff is actually pretty heavy. A lot of people will be feeling a little bit betrayed there. Because a lot of people, and I don't know if the allegations are true, right? But the allegations are pretty heavy. So yeah. What's his seems like the Commonwealth didn't really treat it like a firearms case, or they could have spotted the issues you did. The problem is that most lawyers don't actually know, they don't know guns that well. And because they don't know guns that well, they don't know where the gun issues are. So I see somebody asking Maya. This is about Maya Kowalski from the Take Care of Maya case, also known as the J Hatch case. And so just as a little bit of background on the Maya, Maya Kowalski situation. So Maya went to J Hatch, and there were allegations of Munchausen by proxy relating to her mother. So as a result of that, her mother and Maya were isolated from each other. And at the end of the day, Maya's mother ended her own life. So J Hatch, the hospital, got sued. And at the end of the day, Maya got a huge damage award. Huge. Like massive. And then that was overcome on appeal. So now that and I got to set the goal. So now now that there's the appeal, there's these issues of like, okay, now there is fighting with her lawyers. And so now that gets to be a big deal with the fighting with her lawyers, which is yeah. What is it? You see Munchausen's by proxy in the fictional film The Sixth Sense. Yes. Did her mom really have Munchausen by proxy? almost certainly not. So yeah. Um, so this is going to be a bit of a heavy case. So let's cover some stuff that's we're going to cover something a little lighter first. And then we'll come back to the heavier, and then we'll go on all of that, right? So all right. The one we're going to start with, I think, is we're going to start with some Canadian law. And everyone's like, yay, Canadian law. No, I mean, it's about 3D printing. It's about weapons. So this thing is right up my alley, and I just kind of want to talk about it. It's going to be a short case. It's going to be a short one, a little short discussion, but it's a good warm up. It's a good, get our feet wet on this, right? So let's dive in on this one. I think it's a fun little story. Oh shit. I just realized that a video I was supposed to put out today, I didn't put out. I was supposed to put a video out. So there's also going to be a video out tomorrow talking about a really interesting case with regards to the difference between Canadian and U.S. firearm law, or U.S. appeals law when somebody dies. I was going to say, hey, I put a video out today. You should go check it out if you haven't yet. And then I realized, no, I didn't actually upload it. I didn't actually post it. So tomorrow we'll also have a video that is discussing the difference between how Canada and the US treat it if you die while you're appealing your criminal conviction, because the US has abatement ab initio, whereas Canada just has abatement. And you're like, what do these words mean? Does this have anything to do with basements? No. So we've got a goal now for Runkle Have a Drink. I have two options. I have Paloma and I have beer. So, all right. Let us have a look at case number 1 here. So case number 1 is this one. And I need to actually put it up on the screen. There we go. So this story is from CTV News, and it says 3D printer used to create prohibited weapon, charges laid. And you can see the prohibited weapon that's alleged to have been created, and it is a set of knuckles. So brass knuckles, except they're made of plastic because they're 3D printed, right? So we're going to talk about this one because it brings up some interesting legal questions. They say a 3D printer has led to criminal charges in Owen Sound after police say it was used to create a prohibited weapon. According to the Owen Sound Police Service, this case highlights how commonly used technology can cross into illegal territory. This also illustrates how the police are sometimes the big dumb. The big dumb. And yeah, Ian, have a Werner's ginger ale. I've never actually seen a Werner's ginger ale. So, all right. What this means. So the police said plastic isn't prohibited until you manufacture dangerous things. They say under section 84 sub 1 of the criminal code, brass knuckles are classified as prohibited weapons. This means it is illegal to possess, buy, sell, import, or manufacture them anywhere in Canada. And just give me 1 second. I'm just going to pull up here and what is it? I'm going to drop the link in the comments in case you want to check the article out yourself. You should. So here you go. There's the link in the thing. So the police say, this is a quote from the police, the law does not distinguish between metal, plastic, or carbon fiber brass knuckles, says Owen Sound Police. Any item designed to enhance the force of a punch is considered a prohibited weapon. regardless of the material used. Even non-metal versions can lead to criminal charges if possessed or used. And they say the law applies federally, so provincial or municipal differences do not affect this prohibition. Now, let's talk about this one. Because let's actually go to the law, right? So, it's actually the prohibition on brass knuckles is actually in the regulations. And so here is the text. It says, the device known as brass knuckles and any similar device consisting of a band of metal with one or more finger holes designed to fit over the fingers of the hand. Now, you'll note here that it specifically says that the any similar device must consist of a band of metal. Must consist of a band of metal. So previous case law in Canada has said, well, it's got to be metal. It can't be plastic. It can't be stone. It can't be bread. It can't be cheese. It must be metal. Now, the police were asked about this by one of the news organizations that covered the story. And what the police said is that only applies for CBSA decisions. And the CBSA is the Canadian Border Services Agency. So they said it only matters that it's not metal for imports. And the problem with that is that the reason why you can't import brass knuckles is because they're illegal under the criminal code. So the same interpretation from the CBSA applies here. So in my view, the Owen Sound Police Department is wrong about this, right? They just appear to be straight up wrong as to whether or not these are prohibited items. And so there might be charges for, like, you know, possessing them in public in a situation where it's considered to be dangerous to the public peace. But the simple possession of prohibited weapon charge appears to be wrong. It looks to me like the Owen Sound Police got this wrong. So, whoops. That's not a great look when they're doing a big press release and they've got this wrong. Can we get merch about bread knuckles? I don't know if that would sell very well, but couldn't that also cover ornate rings? Not usually. It wouldn't usually cover rings, but it would cover if they were all joined together. I wanted to get a cat's ear key or cat ear keychain as a self-defense device, but Tennessee considers them a form of brass knuckles. Different places are going to have different rules. So Canada considers metal knuckles to be that, but yeah, not other things. All right, how are we doing on the goal? We are at 4 out of 10. That is awesome. Would a roll of pennies be a band of metal? No, because it specifically says a band of metal with one or more finger holes designed to fit over the fingers of the hand. But one of the things that does actually cover, that is actually covered is, what do you call it? Let me find a picture here of something that is considered brass knuckles that a lot of people don't realize is brass knuckles in Canadian law. All right, so here we go. This is a good image. This is a trench knife. They used to like, this is a U.S. military trench knife, right? They'd provide these for, for soldiers. And the thing is that this is considered in Canadian law to be brass knuckles. There's actually a case about this where they're like, hey, what about these knives? Because they're knives. And they're like, yeah, but it's also brass knuckles. So these would be considered prohibited things. So fingerless gloves with metal on the knuckles. Maybe. Oh, we got to bring this up. Chat, I passed my dissertation defense last Friday, which means I'm graduating with my PhD in computer science this May. That is amazing. And we got to do this. And we've got to do like this. Because I think that calls for like some Potter celebration. So yeah. Yeah, let's I think that we're going to declare the goal met as well, just so that we can celebrate that with a that deserves some celebration. That deserves a glass being lifted. So I've got a canned Paloma here. I don't know if it's any good, but we'll find out. All right. Cheers. That is actually pretty good, believe it or not. So congratulations. That is amazing. One of the things that is actually kind of cool about this is that, about doing the YouTube thing is, you get to see people in your chat, and then you've been at this for years. And then because you've been doing this for years, you get to see people like go and like develop, and their lives are, their lives get better over time and things improve and, things like that. So that is really awesome. Somebody said, what brand is the Paloma? It's the Copper Club. So yeah, I mean, the sad side of that is that I've also had friends on here who have passed, and I never expected that either, where I, where it's like, I did not expect to have sadness out of this. So, yeah. All right. Would a sling ring from Doctor Strange be considered brass knuckles since they span 2 fingers? I don't actually know. Now I'll have to think about that one, but it's a good question. I don't know for certain. I'm taking paralegal classes. I'm skipping tonight because it is work on resume day, and I'm a senior citizen, so no resume for me. Fair enough. Dr. Purple Dragonair says, thank you for all the well wishes, everyone. That is awesome. The Dr. Purple Dragonair is, that's an awesome flex there. Would the police interpreting the law in a public statement be akin to providing legal advice and here a wrong one? No, wouldn't. It's just the police that, doing that. Where would the line be drawn? They're fine there. So yeah. All right. Let's so chat. Well, let's look briefly at the Afroman thing. And when I say we're going to look briefly at it, we're not going to cover much of it. We are, and I'm just going to give credit here. The source of this is the Defense Diaries podcast. Defense Diaries has what is that? And I've dropped a link to their the video here. So the world wonders. I see you said, according to these idiot cops, to 5-year-old me would have been a criminal for sticking a plastic toy on my hand to look like a cartoon character. You're not wrong. So yeah. It's just a short thing, man. We'll be back. The Defense Diaries got the interview with an anonymous juror. And so that's what I want to talk about. So they've got a stream. It's a 2.5 hour stream. We're going to look at just a little tiny bit of it. So if you want to see the whole thing there, you can go check that out. But for right now, we're going to cover a little tiny portion of it. And yeah, we're also doing this with permission. Defense Diaries was like, we're good with you covering it. So yeah, just in case anybody thinks I'm stealing his, stuff, or stealing their stuff. No, we're good. They said I could, so we're going to. All right, so here we go. This is kind of the thing there. Oh yes, tomorrow I'm going to be on Washington gun law. So all right, so this is the portion I wanted to talk about here.
Evidence and the judge's instructions, but I mean, and also none of us knew how court was supposed to work. Is the judge supposed to like keep telling you things throughout? I mean, I didn't know that how bad that was until afterwards, and then I saw a lot of TikTok lawyers and stuff talking.
I mean, that might be me, the TikTok lawyer. So I don't know, but yeah,
About how messed up they thought it was or whatever. But
so let me ask you, because we as lawyers, we always worry that when a judge chastises us in front of the jury, when a judge tells the jury basically this lawyer is doing it wrong, that the jury is just going to be like, well, this lawyer must really be screwing up because this judge keeps saying something. And on the flip side, a lot of people say, well, jurors can sense that when a judge is being a little bit too harsh with one side or the other. For
Absolutely.
you, which way did you take it?
hang on. I mean, I don't want to say, I don't want to.
you hear how much the juror is struggling here, like with, I don't want to say the bad thing, but it's the bad thing.
Bash a judge or anything, but I mean, it did seem like he was on, like he had something against, the defendants or something. But I mean, it didn't factor into our decisions. I mean,
Right, no, I understand it, that it wasn't part of your thought process with deliberations, but just the way you perceived it in general in the moment that it was happening.
Yeah, well, it was one of those things where you could just feel it. It felt uncomfortable.
Yeah.
That's the way I would describe it. Is just felt a little tense, just a little bit uncomfortable. But
It's not a good thing when the judge is making it's not a good thing when the judge is making the jury feel uncomfortable, right?
like I said, again, we didn't know how this was supposed to work, how a judge was supposed to act, or
Right.
so.
Yeah, which makes total sense because you're not going to know, like as a lay person, if you're not an attorney, what's improper for a judge to be doing and whether, so it's like, yeah, I understand that part of it. In terms of when you guys get back into deliberations, did you select a 4-person, right? Did you guys kind of vote on who would be the 4-person? And in terms of the deliberations, did you guys do what we call a straw poll where you kind of go say, well, where's everybody at? Like coming in, because you guys weren't talking, right? Like during the trial,
No.
You can't. So you guys did your straw poll, and where was it initially?
What do you mean? Where was what?
Well,
where were you guys in terms of whether you're going to find them liable? Like as to each count I guess what I'm getting at is was there a split? Like, did you guys have to really deliberate? Did some people have to be talked into certain things, or how did that deliberation go?
No, it was, everyone did a good job of playing devil's advocate, and even the ones that we didn't think for sure right off, just from everything we could remember without looking at our notes or anything, there were, I think 4 that but we still went over our notes. Everyone read their notes, and we went through every piece of evidence and the law was laying in front of us and we just checked off everything as we went.
So let's start with the ones that you could very.
All right. So one of the things I wanted to note there is one of the things the juror speaks about in this interview is basically that they got a sense from the judge that the judge had like a feeling about this. The judge had, or, an impression, and the jury got the impression that the judge wanted one particular verdict, and basically apparently came back to them and asked them essentially, like, what went wrong? Why didn't you find the other way? Which is wildly improper, right? It's and the juror there is talking. We're done with video, so I'm not going to bother fixing anything there, but thank you for letting me know. The jury was like getting the impression that the judge really wanted the jury to find liability. And yeah. So this is a problem, right? But I think that this also goes to show why we have jury verdicts or why we have jury decisions, because at the end of the day, the jury has a much better feeling, much better pulse of the community, right? The jury. And so I think that this case actually really illustrates, this is the, it really illustrates to my mind that juries are important. Juries are critical. And if you actually watch the Afroman decision, you see the judge is like so stunned about this that the judge just kind of flees the courtroom and doesn't thank the jury. Like normally, every time you watch a jury trial, right? Think of every jury trial we've watched. The judge has then gone to the jury and in open court said, thank you for your service. I know this took you away from your families. I really appreciate that, this was a hard case and you put in the thought. And I didn't see the judge do that. I also didn't see the judge, the judge appears to have bailed sufficiently rapidly that everyone was confused about whether or not they were free to leave, right? They were like, what's going on? So I don't want to cover the entire, their entire interview here, but I did want to discuss and, yeah. Did you hear that the plaintiff's lawyer also reached out trying to interview jurors after the verdict? I hadn't heard that. That doesn't surprise me because the plaintiff's lawyer would want to interview jurors, right? And that's not unreasonable. But the bailiff had to come in and dismiss everyone. It was very strange, right? It was very strange because everyone was standing around going, yeah. So, yeah, we're gonna have some, some thoughts there. So it's also in the interview. She got very emotional. They took the same stance as the judge. Where did we go wrong? The plaintiff's lawyer. I felt the plaintiff's lawyer was, I thought the plaintiff's lawyer was a bit too, he was breathing his own farts is the way I'd put this, because the plaintiff's lawyer appears to have, the plaintiff's lawyer appears to have accepted the, accepted this too readily and not really sort of done any thinking about this, because you see the plaintiff's lawyer and he was getting so upset about the things that were said about Lisa, the one person. I'm going, hey, that is not ideal, right? So yeah, I've got some thoughts there. You got to be careful, right? You don't want to have a situation where you've got where you've got a situation where you gotta, how do I put this? You've got to be able to call bullshit on your own on your own case, right? You've got to be able to realize that your own case is crap. You've got to, and so if you if you have a situation there that if you've got a situation where where you are too close to it, there's a reason why if I what is it? Let's imagine Mrs. Runkle got charged with an offense, right? And she's like, I need you to be my lawyer. I would absolutely be willing to be her lawyer, and I would be smart enough not to. Because at the end of the day, it's how do I put this? At the end of the day, I would have a hard time judging Mrs. Runkle's case. And, because Mrs. Runkle comes to me and she's like, hey, she's like, hey, I've got this, here's my defense. And I'd be like, of course the jury's going to accept that defense because I love Mrs. Runkle, right? So I would be having a hard time. I would have a hard time, making smart decisions about it. Whereas, so if Mrs. Runkle came to me and was like, I've been charged with a murder, will you help me? I'd be like, I will absolutely help you by hiring another lawyer. And yeah, I just that is yeah. Outrageous that saying that somebody who likes the same gender is worse than liking children. Yeah, he very much had this thing where it was like, I think that you like that this. He asked for more money for the person who was accused of being a lesbian than the person who was accused of being a like a child sex offender. So I I just I don't know. I've got issues with that. I just, I do. So anyway, I was trying to somebody says, is Runkle distracted? Yes, I was actually reading one of the cases, just trying to decide which case I want to cover next. Because we got a bunch of cases and I was sort of having some trouble deciding what to look at next. And yeah. All right, let's move on, I think. Let's talk about let's talk about the Maya case. So all right, let's have a look at that one here. And here we go. Now, I am going to warn this one does have some difficult things, right? This has some this has some stuff that is a challenge. This has some stuff that's unpleasant in terms of the allegations. And I don't know if the allegations are true, right? Can you give a quick overview? I did give a quick overview, but I'll give another quick overview. So Take Care of Maya case. I keep saying taking care. It's the Take Care of Maya case. What happened in that case is that Maya's mother was accused of having Munchausen by proxy. She was separated from her daughter, Maya Kowalski. Maya was herself, tormented, and the Maya's mother ended up taking her life. And so at the end of all of this, Maya brought a lawsuit against the hospital, which was JHatch. She got a ton of money awarded to her. And then on appeal, that decision was reversed. And now there are issues with respect to the lawyering. We are going to see some of the issues because there's disputes with the lawyering. And we're going to look at that. So this is a fight between Maya and her previous lawyer. So let's talk about that because she does not want to have to pay her previous lawyer, and she's got some serious allegations in that. So we'll do a content warning. There's the content warning. All right, so here we go. So this is her declaration. And again, the content of this is rough. I, Maya Kowalski, declare as follows. 1. My name is Maya Kowalski. Okay, so far, nothing, the first few paragraphs are not going to be super exciting. I'm over the age of 18 and competent to make this declaration. The statements contained herein are based on my personal knowledge. 2, I previously provided a sworn statement on September 2nd, 2025. This declaration is intended to supplement and not contradict that prior statement. 3, over the course of Gregory Greg's representation of me, he frequently communicated with me privately, without my father's knowledge, by text message, email, and telephone. Now, that in and of itself, I don't have a huge issue with. And I say that because I do criminal law. And a lot of the time in criminal law, I have an issue where the parents and the kid, like the kid may not be able to tell the parents what is going on, right? And so sometimes you've got situations where the how do I put it? Sometimes you've got situations where you cannot possibly let the parents know what the kid is doing, right? So one of the examples of that is I had a case where the how do I put this? So the parent was like, I need to know everything the kid is telling you. And I was like, fuck you. No, you pay the bills, but that's it. And yeah, why did they make the banner so big? Is there a way to make this banner any smaller? If I do it this way, will it be smaller? Try it this way. Okay, that's much better. If I do it as a crawl, it's much better. All right. So the problem with this particular thing was that the kid was like, I didn't do it. And I was like, how did you not do it? And how do I know you didn't do it? And he's like, well, I wasn't there. And I was like, okay. And it's like, how do I know you weren't there? It's like, cause I was with somebody. And I was like, okay, good. We've got an alibi witness. What were you doing? And they're like, I was having sex when this crime supposedly happened. I was like, all right. I mean, fair enough. Who's the girl? And he's like, wrong. And I'm like, oh, I see. Because this kid's parents were like super fucking religious, right? And so at the end of it, the kid's defense was, I was busy getting down with another guy. And now I should note, the other guy was also close in age. There was no criminal activity. It wasn't anything like that. It was just guy had a boyfriend. And so I ended up getting like, I let the Crown know that there was an alibi, and the Crown investigated, and they they interviewed the boyfriend. They're like, okay, we got the wrong person. Great. And yeah. So at the end of that, they what do you call it? At the end of that, the charges were withdrawn, and the parents never found out why. And so, yeah, it just. But so I don't necessarily have a problem with the communications directly with the minor, right? Because sometimes that has to happen. But let's go and look at the rest of it, because it gets worse. As time went on, I became increasingly uncomfortable with the tone and content of many of Greg's communications with me. Examples of things that made me uncomfortable are set forth below, and copies of these communications from Greg are available and can be produced if requested. So it's like she's saying she has receipts. Whew. I turned 18 years old in December 2023. Shortly after the new year, Greg arranged and paid for a hotel room for my friends and me. Don't like that. That part I don't like. Greg knew that I had just separated from my boyfriend, and he wanted to cheer me up. I was very upset and emotionally vulnerable at that time. Greg also stayed at the same hotel in a separate room. Why? 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 Right? I mean, if you're saying, okay, I'm going to pay for, her to have a party or whatever, I would want to, like, if I was crazy enough to want to pay for a client to have a party at a hotel, I would want to be in another fucking state when that happened. And I don't mean like California to like, Washington. I mean, like, I want to be plasma. I want to be another state of matter when this happens. While at the hotel, Greg invited me to come to his room. No. All the no. When meeting minors, you want to do this in a place where everything is super, above board. So, like, if I am meeting a minor at my office, I am making sure somebody else is in the office, and I'm making sure that the meeting is happening with the door open. I might, in addition, be like, I am also going to arrange for, hey, this other lawyer is going to sit in on our meeting. Is that okay? Yeah. While at the hotel, Greg invited me to come to his room. When I arrived, it was apparent to me that he had been drinking. Do not drink and interact with clients. Full stop. Like that, those two things are different things, right? Now, I see people say, what is it? I see people say that, what do you call it? What is it? How can you maintain client confidentiality if you have a non-lawyer witness? You have a lawyer sit in. You have another lawyer sit in. And that lawyer, the lawyer is like, this lawyer is going to help me on the file. He's part of the whole thing, right? You don't have a non-lawyer sit in, right? And yeah, teacher here, if I ever have to speak one-on-one with a student, it's within view of a camera or the door is open with another adult in eyesight. Yep. You have somebody there, right? You don't invite a client, any client, to your hotel room while you're drinking. Why are we assuming this is all true? We're not. We're talking about the allegations. We're talking about these are the things that are alleged. We don't know if this is true, right? We don't know. These are allegations here. And we'll have to see what all can be backed up and what all cannot. So while I was alone in his hotel room, Greg rambled on about a variety of things for a very long time. During that conversation, he asked me to sign a new fee agreement because I had turned 18. Now, there is a reason to have the to have like a new fee agreement signed, because contracts you sign after you turn 18 are different than contracts you signed before. So I can get why you might have a new fee agreement signed, but she says, I signed the document he presented to me. Greg did not explain that the fee arrangement might not comply with the rules regulating the Florida bar. I was not advised that the fee percentages exceeded what is permitted or that court approval would be required. At no time did I suggest or agree that Greg should receive a fee greater than what is permitted by the Florida bar. After I returned to my hotel room, Greg sent 2 bottles of wine to my room for my friends and me to drink. All of us were under 21 years of age. So I find this to be a little weird because in Canada, like the drinking age is 18 or 19, depending on which province. And, so the whole 21 thing is weird to me. So, but, yeah. The thing about the Greg sent 2 bottles of wine to my room, that might be documentable, right? This might be something that could be documented where they might be able to, if this was done by a room service, then there's probably receipts, right? So I don't know if we have receipts. I'm just saying if the story is true, this is the kind of thing that you could try to find the receipts for, right? So all of us were under 21 years old. He later came to my room. Greg made many comments to me that were inappropriate. Among other things, he encouraged me to be sexually promiscuous and advised me that I should date older men. He told me that women age faster than men and that older men prefer younger women. He suggested that dating older men would make me more attractive in certain social and professional circles and would help me become connected to influential people. He provided unsolicited advice about using contraception and not getting pregnant. Now, again, I don't know about the allegations here, but this would be entirely in line with sort of grooming behavior. Although at this point, the allegation is that she is, over the age of 18. So yeah, it's a whole sort of thing there. So I have serious concerns about this. Why would she allege this if she can't prove at least some of this? I suspect, but I don't know, I mean, I suspect that she probably got the ability to, to back some of this up, right? Greg encouraged me to pursue a relationship with his 28-year-old nephew when I was just 18 years old. He also encouraged me to drink on several different occasions, and he commented about my behavior and what I wore when meeting his friends. Greg's comments about my sexuality, relationships, and social positioning made me uncomfortable. However, I did not fully appreciate how inappropriate Greg's interactions and communications were. As I matured and spoke with other trusted individuals, I came to understand that Greg's behavior was not appropriate, especially for a lawyer representing a young client. It wouldn't be appropriate for a lawyer representing any client, right? So, yeah. It's a whole thing there, right? So, in July 2024, Greg told me that I was no longer permitted to speak with Nick Whitney, who I understand to be one of my attorneys and who I liked and trusted. If you've got two lawyers, you got to be able to talk to both lawyers. Like, that is weird. Around this time, Greg asked me to sign an affidavit regarding Nick that I believed contained inaccurate statements. I refused to sign the affidavit. I relied on Greg to provide me with accurate and complete information regarding my case, my finances, and my legal rights. By the fall of 2024, I no longer felt that Greg was acting in my best interests. I did not trust him, and I became very concerned about his motivations. Because of this and other reasons, I reached out to Nick despite Greg telling me not to speak with him. In conversations with my father, I learned that he also had significant concerns about Greg, including concerns about his honesty, how he interacted with my brother and me, and concerns about his handling of financial issues. After discussing these matters and others with my family, we made the decision to terminate Greg and Anderson Glenn LLP. With respect to the advance funding loan, Greg never informed me that the Florida bar prohibits attorneys from participating in advance funding loan transactions. Greg did not explain the total costs associated with the advance funding loan, including the magnitude of fees, interest, and repayment obligations. Greg never told me to get independent counsel before the loan was closed or funded. I was also not advised that smaller or less expensive funding options may have been available. By the way, this is the kind of thing that if you're trying to tell a client that they need to get a loan or something like that, that you got to get independent legal advice. You've got to paper your file. You've got to, when I do a guilty plea for the client, I want to, I want to make sure that, you've got stuff in writing, documented, these kinds of things. So it's got to be a thing, right? So Greg did not explain to me that the loan documents could restrict my ability to make independent decisions regarding my case, including whether to settle, retry the case, pursue an appeal, or retain new counsel. Greg did not tell me that the lenders or other parties to the transaction could influence or control these decisions for me. And she's signing under penalties of perjury. So the problem we've got here is that based on these allegations, it looks like Maya, at least, according to her statement here, has been abused and used by everybody in her life for the entirety of it. We'll have to see. I mean, again, these are allegations. It might come down to this does not go anywhere. There's no evidence to back it up or anything like that. But if it is backed up, this is the kind of stuff that ends your career, because this is bad. And if it's not backed up, this is the end of Maya's lawsuit. Because at the end of, if they say that Maya, if they decide that Maya is, if they decide that Maya's lied about this, then she's going to have no hope of getting like a lawsuit to land after that. So I'm just like, oh my God, I really hate all of this. Yeah, he gave up everything. He gave everything up for this trial. I'm not condemning him based on allegations. Law nerds should know better. I'm just saying these are allegations at this point. We don't know. But yeah. Runkle, did you hear from Rob? Is he doing okay? Rob is doing okay is the wrong thing. Rob is dealing with some difficult shit that it's not my business to go into. Right? But Rob is alive. Rob is as good as it's possible to be in the circumstances. Now, the other thing I'm just going to note here is that you haven't missed the Pantsless lawyer. We're good. The other thing to note is that it isn't inconsistent that, how do I put this? Greg gave up a whole lot and he went an incredible, put an incredible amount of sacrifice for this, which could be that Greg is the nicest person who ever lived, right? That is where it could be. Or it could be that things were going on that caused Greg to not be thinking straight and to make decisions that he might not otherwise make. I don't know, right? I don't know which it is. And, I hate this, right? I hate all of this. I hate everything that comes out of this. So, it was such a, huge thing. So, yeah. It's a big deal there. It's a big deal. At the end of the day, we'll have to see what the fallout is, right? Because at this point we've got a bunch of super nuclear allegations, super toxic allegations, and yeah. Coming in way late. Is this related to Take Care of Maya? Yes, that's what we're talking about. Yeah. I just, yeah. All right, let's wrap this one up. What date is this? This was filed March 18th, so just recently. We're going to do this. All right. I like that little banner there. And yeah, the big winners on all of this is J Hatch. J Hatch loves that the lawyers are fighting, right? J Hatch hates that, J Hatch would hate if everything was going well. They love the lawyers fighting. And so now it's this giant shit show, right? So, yeah. Will those allegations prevent Greg from being paid too? Quite possibly. Yes. Quite possibly. It could. I see a good question, or that bumper is so random. I love it. So the story behind that bumper is we used to do a segment, me, Rob, and a shithead used to do a segment that was, I've got a twig in my hair and I'm trying to get it out. It's bothering me. So we used to do a segment of, basically covering famous trials. Trials of the century was what we called it. And so in the course of that, one of the things that came up is we would give a cellophane warning, and I don't know why it was cellophane. I think that was actually something that the shithead came up with. But yes, a twig. I was cutting down a tree, and I got twigs and junk in my hair, and I can feel it, but I can't get it out. It's like this is a little tiny piece of something, so it's bothering me. But yeah. So anyway, that's where that bumper came from. So the bumper is basically a little bit of of that. What is it? How did you get a twig in your hair? So we've got this tree in the backyard, and the tree got mold, and the mold is killing the tree. Like the mold is destroying the tree. And so because the mold is destroying the tree, I'm cutting it down in chunks. So I go out there and I take a sword or a kukri and I chop some bits off it when I've got some spare time. And so then I go and, but in the process, like stuff fell into my hair. Yeah. And I see people saying, who's the shithead? We don't need to name the shithead. The shithead is a shithead. And we're not going to name the shithead. The shithead just sucks. So, yeah. All right. Let's cover, we are racing through stuff, which a sword. You must be new here. Sword. And you can see the edge of this sword has gunk on it because I was using it to chop tree. So sword. I have another sword here, which is kind of buried. I nearly sliced through a cable getting this sword out. I should have used this sword. This sword would have been the perfect sword for that. So so yeah. If you're new here, I got swords. That is a thing. All right. Let us start new. Oh, we have a goal. The goal is for an innocent gun, which is a beer. So, all right. So, let us talk about, let's talk about the other case or another case that I thought was funny with there. And this is an allegation of a lawyer with no pants. Lawyer with no pants. Let's talk about the pantsless lawyer. I don't have a picture for the actual pantsless lawyer, but he is represented in the thumbnail by Winnie the Pooh. And somebody was like, why is Winnie the Pooh in the thumbnail? The reason why Winnie the Pooh is in the thumbnail is because Winnie the Pooh is also famous for not wearing pants. And that is it. It is, we are talking about the pantsless lawyer. So Winnie the Pooh is famous for not wearing pants. So, all right. So this is the case of Brian M. Burton versus Poulin, Wiley, and Estopolo LLC, Lane D. Jeffries Esquire, and Chase H. Coble Esquire. And we're just going to talk about, you're going to see. So it's bad. It's bad. So to the defendants, you are required to attend. We can skip through the summons. Plaintiff Brian M. Burton, complaining of defendants, etc., would respectfully allege and state to the court facts sufficient to constitute multiple causes of actions against the defendants as follows. Summary of the case. This action arises from the egregious and unconscionable conduct of the defendants, one of its managing members, and one of its associate lawyers, all of whom failed to uphold their professional fiduciary and contractual obligations to plaintiff Brian M. Burton during their representation of him in a personal injury matter. By the way, I'm just going to reiterate, all of these are allegations and not confirmed. Somebody's saying, Runkle, prove you have pants on. Pants. I got pants. Or at least my legs have pants. Yeah. Poole & Wiley, a law firm that aggressively markets itself as a champion for clients, promising respect and results and genuine care, engaged in a pattern of gross negligence, unprofessional conduct, and deceptive practices that not only betrayed Mr. Burton's trust, but also caused him significant financial and emotional harm. Despite their public assurances of competence and dedication, Poole & Wiley failed to meet even the most basic standards of legal representation. By the way, the most basic standards of legal representation includes pants. It includes pants. Like, you got to have pants. Pants are part of the basics, right? So, yeah. All right. Poole & Wiley's misconduct included neglecting critical deadlines, failing to communicate with Mr. Burton, and subjecting him to a revolving door of lawyers and staff with no continuity or oversight. Most shockingly, during a critical mediation, defendant Chase H. Coble, Esquire, Mr. Coble, appeared intoxicated, exposed himself, fell asleep, and ultimately abandoned Mr. Burton's case, leaving him to navigate the process alone. Again, these are allegations made in the case. I cannot confirm if they're true. I can merely confirm that the allegations are, on their own, fucking hilarious. Mr. Jeffries, one of Poole & Wiley's managing members. I feel like managing members is the wrong... You can't go to managing members right after you just talked about him exposing himself. You've got to find a new word, a new term, like something else. Was responsible for supervising other lawyers within the firm, including Mr. Coble. Despite being aware of Mr. Coble's alcohol and / substance abuse issues, Mr. Jeffries permitted him to represent Mr. Burton during critical proceedings, including the mediation. This decision demonstrated a reckless disregard for Mr. Burton's interest and further underscored the systemic failures in Poole & Wiley's management and oversight. The firm's lack of adequate supervision and its decision to allow an impaired lawyer to handle Mr. Burton's case were emblematic of broader deficiencies in its management system, which failed to ensure compliance with professional standards and the rules of professional conduct. Poole & Wiley's actions were not isolated incidents, but part of a broader pattern of unfair and deceptive practices that are capable of repetition and pose a significant risk to the public interest. Their conduct violated the South Carolina Unfair Trade Practices Act, SCUPTA, breached their fiduciary duties to Mr. Burton, and constituted legal professional negligence and breach of contract. So he says he has suffered financial losses, emotional distress, and irreparable harm to his legal claims. So he wants money. So much money. All right. So parties, the law firm is a law firm. Lane D. Jeffries is a lawyer. Chase H. Coble is a lawyer. Brian M. Burton is a citizen of South Carolina. All right. Facts. Poole & Wiley runs aggressive get your free consultation campaigns across TV, radio, billboards, digital, and even SMS marketing, with opt-in tick boxes for text messages on their website. Poole & Wiley's website posts these statements. Need a lawyer that will give you the respect and results that you deserve? Contact one of our legal professionals today. We are available 24/7. A key factor in the firm's success is its genuine care for both its clients and employees, emphasizing the importance of its team. Poulin Wiley's litigation page states, when it matters, call us because there is no second place in litigation. Which is why they like the symbol of just one. Oh, I'm a terrible human being sometimes. That was awful. But we are close to the goal with 3 minutes left. All right. In 2022, Poulin Wiley entered name, image, likeness sponsorships with NCAA football players at the University of South Carolina and the University of Georgia. I'm sorry, I'm laughing because I read ahead. That campaign, Go Big, included billboards, radio, digital, and TV. So I got to ask, when his pants were off, did he go big? Was that a thing? I mean, it would not be good if it was like go small, go mediocre. Between 2022 and 2024, more than 7 lawyers and probably many more left their employment with Poulin Wiley. On March 18th, Brittany Hill and Mr. Burton were involved in a motor vehicle collision on Robert Edge Parkway, etc., etc., etc. Ms. Hill improperly crossed into Mr. Burton's lane and collided with Mr. Burton's vehicle. So they accepted the representation of Mr. Burton to pursue a financial recovery on Mr. Burton's personal injury claim arising from the accident. One of the things that's like difficult with US, so personal injury is a much bigger field of law in the US than it is in Canada. And the reason why I say that is because in the US, you have all of these medical expenses that you don't have in Canada. So in the US, you'll get these, medical cases, and it's like hojillions of dollars for the actual, for the actual bills. Whereas in Canada, it's like the medical is typically like, oh yeah, medical expenses of like $18. Okay. It's a bit of a different thing, right? So during this, they advised that Ms. Hill had a $250,000 insurance policy, and that based on the available evidence, they should recover all of the $250,000. I am just like, oh my God, why do you only have $250,000? I have more than $250,000 in liability because that, yeah. Do I have the original filing? I found it, but I couldn't find it again when I was looking just now. So I couldn't find it. I couldn't find it before the stream. I looked at it 3 days ago. So yeah. On February 23rd, Frederick D. Mogab, a lawyer practicing with Poulin Wiley, filed a summons and complaint on behalf of Mr. Burton against Ms. Hill in the Horry County Court of Common Pleas, initiating a civil action on Mr. Burton's behalf, asserting the personal injury claims arising from the accident. Mr. Mogab did not speak with Mr. Burton before filing the summons and complaint. That's weird. You should. State minimums are $25,000. Whew. I think I've got 2 million in coverage. Now it's 2 million Canadian, but you don't want to be in a situation where you end up eating it. runkleofthebailey@gmail.com will reach me. So runkleofthebailey, all one word, @gmail.com. And I will pull up my email here just to I've got some fun transcripts here. All right. So let's see. Yeah. It's not quite that bad, but yeah. All right, let's see that. So carrying on here. On May 23rd, counsel for Ms. Hill filed an answer to the complaint and served her first set of interrogatories and first set of requests for production on the lawyers with Poole and Wiley. Mr. Burton's responses to Ms. Hill's discovery requests were due on or about June 23rd. Neither Mr. Mogab, Mr. Milligan Smith, or any of the lawyers at Poole and Wiley informed Mr. Burton about Ms. Hill's discovery requests. Oh, that's bad. So when the other side submits that, when the other side submits that you've got, or submits these requests, you have to obey them, right? You have to follow them. And there can be serious consequences for failing to respond, especially in some places you've got what are called like notices to admit or requests to admit. It's different phrasing of it in different places. But those things are basically saying a bunch of things that the other side thinks are true. And so it might be like notice to admit Ms. Hill collided with, with Mr. Burton, right? That might be something that they might send as a notice to admit. And if you fail to respond to those, it's treated as everything is admitted, which, can be life ruining if you're not careful about that. So, yeah. On September 10th, counsel for Ms. Hill sent a consultation letter under Rule 11 regarding the overdue responses to Ms. Hill's first set of interrogatories and requests for production. That usually, like these kinds of things are often a first step to like bringing sanctions, right? We're not allowed to bring sanctions until and unless we've taken these steps. So nobody served the responses before September 26th. And so then they file a motion to compel, citing failure to respond to discovery requests served on May 23rd and attach the Rule 11 consultation letter as an exhibit. On October 25th, Poole and Wiley filed a notice of transfer within firm, advising that Samuel D. Bennett is now lead counsel for the plaintiff. So they've now swapped lawyers. This is usually usually you've got to get permission from the client to swap that out, right? So neither Mr. Mogab, Mr. Milligan Smith, Mr. Bennett, nor any of the other lawyers at Poole and Wiley informed Mr. Burton of Poole and Wiley's decision to have Mr. Bennett take over the representation. During the representation, the lawyers at Poole and Wiley, rarely return Mr. Burton's calls. Clients always want more return phone calls than the lawyers want to do. Because for the client, it's their only case in their life, right? But for the lawyer, they have many different files. And so you'll get people who are like, I want to, I want to have, a call every week. And you're like, no, nothing is happening this week, right? Nothing is happening. That happens all the time where you've got, the client wants to have a thing and you're like, no. It is the thing, right? It's, but I mean, you gotta understand, because the client, it's their biggest matter in their life. It's the biggest thing going on for them. And for as a defense lawyer, I'm sitting there and I'm talking to a client and it's like, oh my God, this is the most important thing. And I'm like, sir, you're charged with a minor domestic violence charge for an allegation of pushing. This is not my top priority. I'm going for the guy who's looking at 8 years in jail, not you who are looking at probation. And it's especially bad for contingency file cases and flat fee cases, because Elf Wiggins makes it, that sort of thing usually dies down after they get their first bill. This is the thing, is if they are getting paid by the hour, then you can rack up their bills. Like, then you can just say, hey, those like calls you had for like, every 20 minutes, those ended up costing you $3,000. And the client's like, oh, maybe I should stop doing that. Maybe I'll leave it to my lawyer to, update me. But personal injury cases are often done on contingency, i.e. the lawyer gets like, 30% or whatever it is of the file. And so if the lawyer is getting 30% of the file, then it doesn't matter how many phone calls you make. It just straight up. Okay, failed to maintain consistent communication with Mr. Burton, resulting in a 3 to 4 month period during which Mr. Burton received no updates on his case, despite repeated attempts to contact the lawyers at Poole & Wiley to find out the status of the case. This is the thing, is that if the lawyer is saying, hey, what's the status of my case, you should respond, right? Yeah. Subjected Mr. Burton to a lack of continuity and representation as he never spoke to the same lawyer twice and was shuffled between various lawyers' assistants and paralegals without clear coordination or oversight. And then D, did not maintain regular business operation hours for their offices in Myrtle Beach, as Mr. Burton went to their offices in Myrtle Beach during regular business hours, but the doors were locked and no one was present, relegating Mr. Burton to leave a note on the front door requesting a call. Okay, that's not great. I have a lawyer who does like my trademark stuff, and I email her, like, we have an email like once a year. Not a big deal, right? So yeah, and that's not, I'm not upset by it. That's expected. So someone at Poole & Wiley informed Mr. Burton that a mediation had been scheduled to begin at 10 a.m. on May 2nd, 2025 at an unrelated law firm located in Myrtle Beach, and gave him the address for the mediation. You should do prep for a mediation, potentially, right? On the morning of May 2nd, Mr. Burton left home early to ensure he would arrive at the mediation on time, but using the address that Poole & Wiley provided, he could not locate the law firm where the mediation was to take place. Mr. Burton called the Poole & Wiley offices several times and finally obtained the correct address. That's not good. Mr. Burton arrived at the offices where the mediation was being held around 10:02 a.m., just a few minutes after it was scheduled to begin. When he arrived, Mr. Burton learned that although the mediator, opposing counsel, and the adjuster for Ms. Hill were present, neither Mr. Bennett nor any other lawyer from Poole & Wiley was there. Mr. Burton was waiting in a room by himself, and Ms. Hill, her lawyer, and her insurance carrier were in another room. By 10:35 a.m., no lawyer from Poole & Wiley had arrived or even called Mr. Burton or the mediator. Around 10:35 a.m., Mr. Burton called Poole & Wiley to let them know that no lawyer had appeared at the mediation. Around 10:45 a.m., the mediator came into Mr. Burton's room with a laptop advising, "Your attorney is on Zoom." That's not good. Your attorney should be there in person for something like this. The other lawyer is there in person. The Poole & Wiley lawyer on the Zoom session was Mr. Coble. To Mr. Burton's knowledge, Mr. Coble had no involvement whatsoever in representing Mr. Burton until the mediation on May 2nd, 2025. Mr. Coble made an opening settlement demand of $100,000, which was 4 times the available insurance policy limits of $25,000. Okay, so previously it said $250,000. Now it says $25,000. $25,000 is nothing. This surprised Mr. Burton, prompting him to request that the mediator leave the room so he could speak to Mr. Coble privately. After a short discussion, Mr. Coble told Mr. Burton that he needed to contact another Poole & Wiley lawyer to discuss Mr. Burton's case. This is not going well, right? While Mr. Coble was discussing the case with the other Poole & Wiley lawyer, Mr. Coble did not turn off the camera, but did mute the microphone. While Mr. Coble was discussing the case with the other Poole & Wiley lawyer, Mr. Coble was drinking a beer and using a vape. Now, I hope the vape was just tobacco, but while Mr. Coble was apparently discussing the case with the other Poole and Wiley lawyer, Mr. Coble stood up and walked away from the camera, revealing that he was wearing a button shirt and a suit jacket, but was not wearing any pants. So he's literally doing the Winnie the Pooh, where he's got the like the shirt, and then just below that, it's free tackle. When Mr. Coble returned to the camera, he propped his feet up on his desk, still wearing no pants, with the camera angle straight at his crotch, exposing his genitalia. I would say this behavior is nuts, except it isn't just nuts. It's the full tackle. It's the nuts. It's the sausage. It's the whole thing. This is like, I have never been this business casual. Like, this is business super casual. After a while, Mr. Coble put his feet down, stared at the camera, rubbed his eyes, and fell asleep. Now, I hope when he's rubbing his eyes that what he was handling just before that was not the Franken beans, right? Because is he rubbing the Franken beans into his eyes? That's not good for your eyes, folks. Like that is not where the Franken beans goes. Mr. Coble slept for 4 to 5 minutes before waking up and ending the virtual mediation connection. Mr. Burton notified the mediator that Mr. Coble was no longer on the virtual link and was probably thankful for that. In an effort to continue the mediation, the mediator contacted Poole and Wiley to get Mr. Coble's cell phone number. Once the number was available, the mediator had Mr. Burton call Mr. Coble while the mediator attempted to reestablish the virtual connection. Mr. Coble answered the call saying, "Yeah," with speech that was slurred and almost unintelligible. I love how they use the italics for the "yeah." Like, for the slur, that we're going to tilt the letters to the side just to indicate how much he's slurring. Because, wow, this is the case that really has everything. It's the case for the man who's got everything, like a very, very strong stomach. So Mr. Burton responded saying words to the effect of, "This is Brian Burton, and we were on Zoom for the mediation, and you turned the Zoom on." And I would have also added something like, "And could you put on pants if you want to, like, you know, engage in lawyering for the day?" While Mr. Burton, and we've opened the Innocent Gun. I don't know if you guys are familiar with Innocent Gun. Oh, yes, please do send me the ruling as well. I don't know if you guys are familiar with Innocent Gun. Innocent Gun is a beer that is brewed in whiskey casks. It's actually really tasty. And no, I am not I'm not sponsored by Innocent Gun, but I would like to be. Innocent Gun, call me. We'll do it. All right. So while Mr. Burton was still on the call with Mr. Coble, Mr. Burton informed the mediator that Mr. Coble had been drinking and that he did not wish to move forward with the mediation. Mr. Coble heard Mr. Burton's comments to the mediator and responded admitting that he had been drinking a little this morning. I'm sorry, if you are drinking to the point where you are showing up, you know, like where both the Winnie and the Pooh is visible, that, you know, that's more than a little, right? That's a big deal. The mediator suspended the mediation. Mr. Burton contacted Poole and Wiley multiple times over the next 2 days, asking to speak with someone higher up to discuss his case. And I imagine those calls went something like this. Poole and Wiley. "Hi, this is Mr. Burton. What the fuck?" And can I speak to somebody senior so that I can ask the very important question of what the fuck? Yeah. Yeah. No, he can't be 3 sheets to the wind because he had 1 sheet, the shirt. He had 2 sheets, the jacket, but he didn't have the 3 sheets to. Yeah, the third sheet he needed. He needed that third sheet. He was only 2 sheets, and that's a problem. So on May 6th, Lane D. Jeffries, a lawyer with Poole and Wiley, took Mr. Burton's call. Although Mr. Jeffries apologized to Mr. Burton, he sounded like this was not a big deal and acknowledged that Poole and Wiley was aware that Mr. Coble had a drinking problem and wanted to help him. Here's the thing. It is a really good idea to help out a lawyer who's got a drinking problem at your firm. It is a really bad idea to help out the lawyer with the drinking problem by just letting them continue to do the things. You should pull them off their files, get them into treatment, and then after they are in treatment, you can, like, once they are sober, then you get them back on files, right? It's like, oh yeah, this guy's a race car driver with an alcohol problem. You don't be like, oh yeah, well, he can just keep driving the car while he's drunk. Sure. No. This bad. So bad. During the conversation, Mr. Burton made a monetary demand and advised Mr. Jeffries that if the demand was not accepted, he planned on filing a disciplinary complaint. Mr. Jeffrey advised that he got back in touch with Mr. Burton after speaking with his partners. By the way, that might be extortion. We don't know. That can be a problem. On May 7th, Mr. Burton received an email from Mr. Jeffries rejecting Mr. Burton's demand. In his May 7th email, Mr. Jeffries advised Mr. Burton that they were filing a motion to be relieved as his counsel, falsely claiming that his demand for payment of money and a threat to file a disciplinary complaint is specifically forbidden by our rules of ethics. Might actually be a crime. This might be a problem, right? So, yeah. ABQ Cat saying, I know you like your sword and kukri, but wouldn't a handsaw and/or machete work better for tree trimming? The kukri is basically a machete, so it works great. Handsaw is, it's okay. The moldy wood doesn't do all that great. Also, ABQ Cat, could you shoot me a Twitter DM or something, or an email? I've been thinking for a bit on something you said, so I would like to get in contact if we could. So, yeah. All right. Rule 4.5, the rules of professional conduct governing lawyers practicing in South Carolina, generally provides that lawyers are prohibited from threatening professional disciplinary charges solely to obtain an advantage in a civil matter. Mr. Jeffries' statement to Mr. Burton was false because it implied that Mr. Burton, who is not a lawyer, was somehow governed by the rules of ethics, which only prohibits lawyers from threatening professional disciplinary charges solely to obtain an advantage in a civil matter. Because Mr. Burton is not a lawyer, he is not governed by the rules of professional conduct. Okay. Now, the thing, yeah, if it's a fee-based dispute, it might be allowed. It might similarly be allowed if he's got a dispute for, you guys fucked my claim, and because you fucked my claim, you have liability to me. I'm willing to settle the liability to me in exchange for, in exchange for money, right? I'm willing to settle it on that basis. So, yeah. All right. This one is going to be like, that's a thornier issue there. Because Mr. Burton is not a lawyer, he's not governed by the South Carolina rules of professional conduct. So the statement that his threat is specifically forbidden by our rules of ethics were and are false and deceptive. Now, I saw somebody in the chat asking, which rule of professional conduct requires them to wear pants? And the thing is that there isn't going to be a specific rule of professional conduct about pants. and about like not swinging dong in the middle of a mediation. And the reason why is because this is going to be one of the many, many things that the Bar Association probably didn't think needs to get spelled out specifically. Like, hey, you shouldn't show your dick on camera. Is like, okay, cool, awesome. Madam Jenkins says, Ruggles, you are too generous. Nothing was swinging. A little tiny swing set is still a swing set. But there is a general rule that basically says, and like all bar associations have this, which basically says you are not allowed to do anything that would bring the profession of law into disrepute. And so, like, you know, if you sit there and you got your metronoming, that's covered under the whole thing that says that you cannot do the, you know, do unethical things. So, yeah. Mr. Burton contacted multiple lawyers asking if they would take over the representation, but was unable to find a lawyer willing to take over, which was likely due to the advanced stage in the litigation and Poole & Wiley's charging lien in their fee agreement and other factors. So here's the problem. When you go to a law firm and you're like, hey, I want to hire you on a contingency basis. They're like, all right, you now owe us 30%. And if you fire them, you may still owe the 30%. And they may actually get a lien on your claim that allows them to take their 30% before you can take anything. Right? So, and that's even if they like bust out the world's tiniest swing set. You know, if Tarzan's vine is, you know, out of the jungle, right? So without counsel, Mr. Burton was able to negotiate a settlement of his claims against Ms. Hill, but was able to recover only $500 of the otherwise available $25,000. Whoops. So Poole & Wiley's acts and omissions were unfair and deceptive because they did not provide him with the respect and results they had advertised. And yeah, all right. So first cause of action, violation of the Unfair Trade Practices Act. They said basically that they advertised respect and results and genuine care, and they offered fuck all. Yeah. Second cause of action, for breach of fiduciary duty. Fiduciary duty is a duty that requires you to basically treat the other person's claims more with, like, you have to put their interests above your own interests to the extent that they conflict. And if you are unable to do that, or if you have a conflict that threatens your ability to do that, then you can't do that. You know, you can't take the file. So when you're thinking about, like, what is your fiduciary duties, you probably have a fiduciary duty to wear pants. Like, there's probably arguably a fiduciary duty to wear pants in proceedings. Right? I'm also going to talk about why this law firm is kind of a shitty law firm. And, you know, at least based on my impression of things here. So yeah. So they note that he failed to meet the minimum standard of conduct when they sent an alcoholic to the thing, and breached the fiduciary duties by consuming alcoholic beverages during the live virtual mediation session. Here's the thing. We are having a live right now. This is a live broadcast. and I am enjoying a really tasty beer. Pinkies up with the tasty beer. But this isn't court. If this was a court proceeding, I would be wearing my suit jacket and at least some pants. I will admit, I have attended court proceedings with a suit jacket and like just regular pants, right? I call that the legal mullet. You know, business on top, party on the bottom. But you still have to wear pants. And you know what one of the reasons why you have to wear pants is? Because some judges say, all rise. And they actually expect you to do that. And I mean, depending on where your camera is, yeah. Or you must wear pants. And Geek Butts. This is awesome. Hey, Runkle, just wanted to thank you for inspiring me to be a brave noodle to help someone today. I saw a violent crime being committed and found the nerve to call for help while everyone else just stood and watched. I thought, what would Runkle do? I love that. I love that, Geek Butts. That is amazing. It's part of why I have my motto, which is my sort of personal motto is I'm somebody, which sounds like egotistical when you say I'm somebody, right? But what the I'm somebody means, what that's about is when you sit around and you see something where you're like, somebody ought to do something. Somebody needs to do something about this. You know, it's like, I'm somebody, so I will do it. And I mean, often this comes up for like minor shit, right? You go for a walk and it's snowy and icy and the snow and ice is starting to melt and you see that the storm drain is blocked and it's starting to create a flood. You're like, somebody ought to do something. Well, I'm somebody, so I'm going to go get the ice chipper and chip that out. You know, that kind of thing. But I mean, the violent crime thing, absolutely. You might have saved somebody's life. You might have saved somebody's, you know, function. There's a lot of fights where one more fight ends up crippling the person or, you know, or killing them. So I'm somebody, good on you. So yeah. All right. Mr. Coble failed to meet the minimum standard of conduct and breached his fiduciary duties by standing up without wearing pants, revealing his private areas, and later sitting with his legs propped up in a manner that further exposed himself. Yeah. Okay. So, third cause of action, legal professional negligence. I feel like it is professionally negligent to, for instance, not wear pants. Yeah. Breach of contract. Their contract said they had to provide competent representation, and they didn't by not wearing pants. There's a lot of like no pants issues on this file that, yeah, I feel like you got to wear the pants, right? That's just not optional. You must pants at all times, pants. So are we done with this one or do you want more of the no pants lawyer? I feel like we need more no pants lawyer. And we mostly need no pants lawyer because this one has no visual aids. If this one had visual aids, then we would have too much of, well, I'm just going to move hastily onward from that. I'm like, I don't like anywhere that thing goes. All right. So let's look at the original filing. And the original filing is filed as it's filed as a pro se matter. So I'm not going to show this guy's email address because this guy's been through enough. He's had to see his lawyers, his lawyer's dingle dangle. So he's had a rough life. He doesn't need that. So yeah, here we go. I'm currently represented by Wiley Poulin and Anastapolo Law Firm. They are the firm that has filed the case above. Recently, this firm scheduled mediation for me on a Friday, May 2nd, 2025 in Myrtle Beach at Bob Calamari Mediation. Calamari? Shit, now I'm hungry. This firm gave me the wrong address, but I ended up finding the location and arrived at 10:02. The mediator, Bob Calamari, stated that my attorney hasn't arrived yet. 10:35 a.m., there was still no attorney, so I contacted the law firm to notify them. About 10 minutes later, Mr. Calamari comes in with a laptop and says, your attorney is on Zoom. Long story short, this is one of the problems with self-reps is that they file something that says something like long story short. And the thing is that when you're filing shit, you need to file the long story long. Right? You got to file the long story long. So yeah. Long story short, the attorney this firm assigned to cover the mediation at the last minute was Chase Coble. Mr. Coble did not have any dealing with this case until the day of mediation. Mr. Coble was seen on camera drinking a beer. Later during the meeting, Mr. Coble had to confer with another attorney and placed me on mute, but did not turn off the camera. Mr. Coble then stands up to leave the room and exposes himself by not having any pants on. Mr. Coble comes back with the video still going and prompts his feet up on the desk and his legs spread wide open. A minute later, Mr. Coble puts his legs down and starts to rub his eyes and falls asleep for 4 to 5 minutes, then wakes up and turns the camera off. I notified Mr. Calamari that Mr. Coble was no longer on the Zoom call. Mr. Calamari gets Mr. Coble's cell phone number from the firm and has me call him. Mr. Coble answers the phone. Yeah. I said, this is Brian Burton. We were on a Zoom call with mediation. You turned the Zoom off. The attorney then starts to say in a slurred speech something about going to his car to take the call. Wait, his car? His car? Where's the goat? I have the violin, but I need the goat for this. This is goat. This is not violin time. This is goat time. Where is my goat? My desk is a cluttered mess. Where is my goat? You know what? We're just going to do the goat manually. Ah! We're going to manually goat. Ah! I said, you're going to take a Zoom call from your car? Mr. Coble replied, you're right. That's probably not a good idea because you're sauced as fuck, dude. Like, you, sir, are sauced. So I then meant to hit the mute button to speak privately with Mr. Calamari, but I accidentally hit the speaker button. I said to Mr. Calamari, he's been drinking and I do not want to proceed. Mr. Coble then says, you're right, Brian. I have been drinking a little this morning. Mr. Calamari jumps in and says, maybe we should reschedule mediation for another day. I contacted the law firm and asked to speak to someone higher up to discuss the matter, and I was told for 2 days that someone would contact me. I finally got a hold of Lane Jeffries, and Mr. Jeffries apologizes and acts like it's not a big deal, and even acknowledges that Mr. Coble has a drinking problem and wants to help him. I state to Mr. Jeffries that when this case first started, my then attorney, Isaiah, I can't recall his last name, stated that the defendant had a $250,000 insurance policy, and if their insurance did not want to settle that, we would go to court and we would ask for $250,000, and we would win based on the evidence. The offer made at mediation prior to Mr. Coble becoming completely inebriated was $100,000. I told Mr. Jeffries my expectation for a settlement were $50,000. Mr. Jeffries stated that he could waive the legal fees and would see what we could get. I stated no after the embarrassment and unprofessionalism that the firm displayed by having Mr. Coble represent me. I wanted $50,000. This was to cover the settlement plus compensation for Mr. Coble's behavior of exposing himself to me while I have been a victim of sexual abuse in the past. Okay. Runkle, you need to cover the lawyer used AI and cited fake cases. Which one? That's like a regular section, regular thing on this show. I stated that I didn't have a letter written to the Office of Disciplinary Counsel, but I did not want to ruin someone's career, especially if the firm wanted to keep him with the firm. Mr. Jeffries stated, we would appreciate it if you didn't write to the ODC, but we understand that if you feel you need to, that it was your right to contact them. I stated that I would appreciate it if we could settle this case quickly, as it has been dragging on for more than 2 years. Oh, honey. Oh, honey. This one, I'm just going to go. Your case has been dragging on for more than more than 2 years. Yeah, that's not surprising at all. 2 years is nothing. And also, I don't think it was dragging. I mean, Mr. Coble might have been dangling like a little bit, but I don't think he reached long enough down to drag, unless he was like, army crawling or something, right? So so Wednesday, May 7th, I received an email from Mr. Jeffries regarding a letter of intent to move for relief as counsel. In the email, Mr. Jeffries states it is because I was insistent that he pay me money or I threatened to send a letter to the ODC. That is not true. The money I was insistent on was involved around the value of my case, plus compensation for the actions of Mr. Coble. Mr. Jeffries is making it sound like I was blackmailing him for millions of dollars. I strongly oppose Mr. Jeffries' motion for relief of counsel. Mr. Jeffries' law firm has handled this case for over 2 years now, and we're at the conclusion of it. To back out now would put it in a financial burden by having to hire another attorney. Furthermore, Mr. Jeffries' firm wasted my time on Friday, May 2nd by having me miss work to attend a circus for mediation, costing me approximately $150 in lost wages and mileage for that day. I would ask that the court not allow Mr. Jeffries' firm to be relieved and instead settle this case with the defending party ASAP for the maximum amount possible. Which do you want? Do you want a settlement ASAP or do you want the maximum amount possible? If the court should grant Mr. Jeffries' motion, I ask the court to at least order Mr. Jeffries' firm to compensate me for my lost wages and lost time for the embarrassment and unprofessional conduct by his firm. Thanking the court in advance for your help, Brian M. Burton. So, I am just going to say here that I think this law firm did a big dumb. Because either they're in a position to say, look, this never happened and we're going to fight this to the ends of the earth because fuck y'all, this never happened, right? And if that's the case where they're like, look, this never happened, so we're not paying you shit, and we're firing you because, but if the lawyer was like, if he was swinging lint or whatever it is that he was, rocking, you should absolutely look at a case like this and go, okay, the limit is $25,000. Fuck this shit. Fuck this shit. Because I'm going to tell you, if I was like, if I was a lawyer who, you know, had the pinky finger at, you know, at high noon there on the, you know, on a Zoom call, and I'd be telling this guy, you know, when this guy calls in and is like, hey, I demand $50,000. Yes, I'm a lawyer. I am not a lawyer who shows his dick on video. Like, look, whether or not this is an anaconda or a little tiny, you know, whatever, is between me and Mrs. Runkle. That is not something the world needs to you know, to share in. And, you know, like, so, but if that was something that, like, you know, was on stream, like, if that was something that came up in a video mediation or whatever, I would be like, look, we will happily pay you the $25,000 that you were going to get from the settlement, and we're going to waive our claim. So take the 25 grand and don't file this publicly. You know what? We'll take it up to 35,000, and you are going to sign the sort of non-disclosure agreement that, like, you know, if you even think of violating it, all of the birds in the city just take off at once. Like, that is the kind of non-disclosure agreement we're going to, you know, have you sign. This thing is going to be signed in, like, you know, it's going to be stamped with, like, black wax. And, you know, it's going to be some, you know, it's going to be witnessed by, like, you know, some bald Catholic priest who stares a little bit too long, right? It's going to be some creepy ass Dracula shit that we're going to do for this non-disclosure agreement. And, you know, just saying. So this is why I feel like the law firm may not be making the best tactical decisions, because holy shit, I would want this to go away so fast and so, I was going to say so hard, but I'm thinking, like, this case sounds with the amount of intoxication, probably semi-hard at best. Oh my God. So, lawyers of the world, if you need to, get a stapler and, like, physically staple your pants to your body, because there is no circumstance where you should ever be going, like, you know, Winnie the Pooh in something like this, right? Like, just, oh my God. It's, I just can't, I just can't, right? Like, this is ridiculous. Now, I mean, there may be some proof issues here. They could potentially, on this case, end up calling whatever other lawyer he was consulting with to be like, so, did you see your coworker's dick? And we don't mean, like, in general. We mean on this specific day, in this specific context. Because if you saw his dick some other time, that's between you and the fence post. But, like, on this particular day, did you see your coworker's dong? Like, was that a thing? Yeah, it's and the mediator shouldn't be bound by privilege and was there. Yes, although the mediator I don't think saw the dong. Cause yeah. Yeah, I'm just crap. I gotta figure out if this is an urgent call because I may have to take a few minutes. Just gotta see if I gotta, yeah. So there was actually a ruling here, and this is interesting. We can cover the ruling here. The ruling is basically they wanted to bring in the mediator. So they're asking for a thing to ask as to whether the mediator is required to respond to a request for information in connection with its investigation as to whether misconduct occurring during the mediation is a thing. And what they say is, yes, the mediator actually does have to respond. Yeah, that is a whole thing. Deal with the thing. The thing is apparently not urgent, so we're okay. Let's cover one last case. One last thing. So we're going to cover the case of what happens if you get what you order. Oh, and I need to start new goal. Okay, new goal. All right, here we go. So nobody sees the that is between me and Mrs. Runkle. That is so I started a new goal to have another Paloma. But we're going to cover the case of what happens when you get what you fucking ordered at a restaurant. Here we go. So this is the case of Kowalski and LTN 1 Times Square doing business as Los Tacos. So this is a guy who is suing a Los Tacos. So put that into perspective here. Plaintiff Kowalski proceeding pro se. You don't say. This guy couldn't find a lawyer to take on his file on contingency, and there's probably reasons for that. Alleges he suffered severe physical and emotional injuries. Was the emotional injury that he was a wuss? Including burns and GI distress as a result of unknowingly consuming excessively spicy salsa at Los Tacos No. 1 Times Square location. Before the court are competing motions for summary judgment. Upon review of the undisputed facts, the court concludes that Mr. Manns' claims fail as a matter of law. Accordingly, the court grants summary judgment to defendant Los Tacos and denies Mr. Manns' cross motion. Background. The following facts are undisputed by the parties unless stated otherwise. Plaintiff Kowalski is a German citizen who traveled to the United States for a vacation in August 2024. And this, by the way, leads us to conclude that maybe Germans are wusses because what the fuck? Right? What the fuck? Come on. So, what is his beef with this? On his trip, he visited the Times Square location of Los Tacos. Mr. Mann stated that as a German, he had never eaten tacos before, and he wished to try the acclaimed tacos offered at the defendant's establishment. Mr. Manns went to the counter and purchased 3 tacos. Los Tacos has a self-service salsa bar featuring various types of salsas with different ingredients and spice levels. At the bar, Mr. Mans proceeded to put hefty portions of salsa on top of all 3 tacos, 2 receiving a red salsa, and the third a green salsa. The green salsa, which Mr. Mans admitted he had never sampled, smelled, or asked an employee regarding the contents before consuming, is the source of this litigation. Mr. Mans claims that after a single bite of the third taco, he immediately began suffering severe physical symptoms. He alleges that his tongue burned, his mouth hurt, his face turned red, and his heart rate soared. He also alleges that he suffered severe GI distress and mouth sores that lasted for days. See, here's the thing. I've eaten a lot of spicy shit, and I've never had mouth sores as a result. I'm suggesting that maybe the mouth sores might have had a secondary cause. Did you meet a young woman on this trip? Because that might have been the mouth sores. It might have been from like the 4th taco you had on your trip, not the 3 tacos. Just saying. Anyway, cheers. Just also saying, dill pickle reaper. Pretty good. So he tried to wash down the spice with a Coke and later some ice cream to no avail. He then returned to his hotel where he took over-the-counter medicine for diarrhea, acid reflux, and stomach cramps that he brought with him on the trip. Mr. Mans called his wife to report the ordeal. Have you ever been such a wuss that you had a taco and you had to call your wife to be like, I've been killed by a taco. This taco hurts. So he also immediately took many photos of the restaurant and his tongue, purporting to document his symptoms. However, he never told anyone else of the incident, including people at the restaurant. Nor did he seek medical attention either in the United States or upon returning home to Germany. Mr. Mans continued with his trip as planned, attended the U.S. Open, and ate meals as normal without issue for the remainder of the trip. According to Los Tacos, no one has ever complained about the spice levels of their various salsa offerings until Mr. Mans, because it's a chain taco place, right? A chain taco place probably has salsa in the range of like mild to extremely fucking mild that like a baby could use as eye wash. It is very rare that a chain restaurant will have a salsa that actually has any sort of oomph to it in any form. And quite frankly, if Los Tacos did have a salsa that is capable of killing you, I would be booking a trip to Times Square right now and being like, I want the taco that killed a man. Like 100%, I'd be like, I want this taco that like apparently took out this tourist, right? And don't Runkle, there are better tacos in the city. I mean, I feel like there are better tacos in any city. But he claims he is particularly vulnerable. Mr. Mans has a pre-existing sensitive gastrointestinal tract and spice intolerance. Then why the fuck are you getting the tacos with the salsa and like... I have spice intolerance. I would like the tacos. And I'm just going to say, New York City's tacos are like, New York City is sufficiently not the place I think of hot sauce enough that it went into an advertisement.
For this dog made New York City. New York City.
We're gonna do that
Well,
again.
this Doug made New York City. New York City.
Oh, yeah. Tide is pointing out red iguana in Salt Lake City. So Tide, I'm gonna I don't know if Tide is whatever. I'm gonna tell you the story. Tide is really not good with spice. Like really not good at spice. And so we went to this restaurant and it's red iguana. It was actually really good. And it was so Tide ordered the nachos, like, and the thing about the red iguana is that the nachos there actually they make their own tortilla chips, and the tortilla chips they dust it with some chili powder. So those were really good tortilla chips, but Tide could not handle them because they were too spicy. Fair enough, right? But like this guy is like, I can't handle spice. I'm just gonna like load on all of the salsa. It's like, dude. I mean, I am a spice fiend. I like spicy stuff. When I encounter a new hot sauce, I try it with a toothpick. Why? Because there are some hot sauces out there that absolutely wreck me. Notwithstanding the fact that I've been able to do a hot ones challenge. There are hot sauces out there that absolutely ruin me. And I mean, this is the other thing. If you go to a Thai restaurant and they ask how hot, if you really want to die, you can just be like, hey, I will have it the way you have it. Against the Tide, says he. Somebody was saying, who or what is a Tide? Against the Tide is my longest standing moderator. So, yeah. I mean, I like hot stuff. It is what it is, right? So, yeah. Yeah. All right. In 2010, Mr. Mans even underwent a colonoscopy after experiencing diarrhea and was advised that he had a reaction to excessively spicy food. He accordingly generally avoids spicy foods at home. Then why the fuck is he putting the salsa on his food? But even though Mr. Mans knew that he should avoid too spicy hot foods, he nonetheless went to Los Tacos and placed multiple heapings of salsa on all of his tacos. This is like if I had a brain injury and just decided that I wanted to like fight Mike Tyson. Which hot sauces were the hottest? The hottest sauce I own is actually the Apollo hot sauce right now. Let me just dig it out. No, when I say dig it out, I mean out of the box, not the way that other lawyer was digging it out. That's a different digging it out. All right. So, Hot Ones, The Last Dab is actually really hot. Tastes pretty good, believe it or not. I like it. But I'm not going to chug it because I'm not that dumb. But I am going to put a little bit on my thumb. And, tasty, but oof. That does kick me a little bit, but it's good. So, yeah. All right. At the close of discovery, both Mr. Mans and defendant moved for summary judgment on all claims. As Los Tacos notes, Mr. Mans relies solely on his subjective testimony for any evidence of injury and damages. Like if you're claiming damages, you usually want, whatever. I am behind on super chats. I will get to the super chats very quickly here. Runkle, my partner has a traumatic brain injury, and the Mike Tyson comparison got a belly laugh out of him. Lol. I mean, right? You're not going to go fight Mike Tyson if you've got a TBI, right? It's just like, figure it out. So, Los Tacos also argues that Mr. Manz's claims fail as a matter of law for the failure to establish the elements of negligence under New York law. To support his claims, Mr. Manz cites no evidence other than his own testimony, pictures of his tongue, and images from Yelp showing that Los Tacos used to label salsa as spicy or medium. Further, as defendant highlights, the image attached to Mr. Manz's motion indicates that the green salsa that was excessively spicy is clearly marked as the medium spice salsa, while the red salsa that caused no issue is marked as spicy. Dude, have you considered that you might just have an allergy for, like, you know, maybe you just have an allergy to, like, tomatillo or something, you know, or yeah. Legal standard. Summary judgment is appropriate where there's no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. So, skipping ahead. In ruling on a motion for summary judgment, the court must view all evidence in the light most favorable to the non-moving party. So basically, the case will survive if it's possible to survive, right? So, yeah. But the non-moving party must advance more than a scintilla of evidence and must demonstrate more than some metaphysical doubt as to the material facts. The non-moving party cannot defeat the motion by relying on the allegations in its pleading or on conclusory statements. Affidavits submitted in support of or in opposition to the summary judgment motion must be made on personal knowledge, shall set forth such facts as would be admissible in evidence, and shall show affirmatively that the affiant is competent to testify to the matter stated therein. Where, as here, the plaintiff opposes summary judgment, the court is required to accept all sworn statements by the plaintiff as to matters on which he or she is competent to testify, including what he did, what he observed, and what he was told by the company managers. All right, skipping ahead a bit here. In the rare case where the plaintiff relies almost exclusively on his own testimony, much of which is contradictory or incomplete, to establish a triable issue of fact, it may well be impossible for the court to determine whether the jury could reasonably find for the plaintiff, and thus whether there are any genuine issues of material fact without making some assessment of the plaintiff's account. So, all right, discussion. Mr. Manz alleges several claims under New York state law stemming from the Salsa incident. These include negligence, gross negligence, and a claim under New York general business law, and a motion for sanctions. And they note, the court notes that Manz's complaint just barely alleges a sufficient amount in controversy for diversity jurisdiction, requiring punitive damages to surpass the $75,000 threshold. How's he asking for punitive damages on Salsa Be Hot? Jesus. Negligence and gross negligence. He's failed to state a claim that they negligently served excessively spicy salsa at the Times Square location. So why is that? Where a negligence case stems from allegations of a food product, a plaintiff must prove that the product served exceeded the reasonable or customary standards for such a product. And they cite two cases about finding that the coffee was superheated or too hot was insufficient to show that coffee was so hot that it exceeded the reasonable or customary standards for such a product. Only then does a business have a duty to warn a customer of the abnormal nature of the product. I mean, they could, for instance, warn you by calling it salsa or hot sauce, which is what, you know. So a food provider is not liable for injuries resulting from some allergy or other personal idiosyncrasy of the customer found only in an insignificant percentage of the population. While the court is unaware of any direct application of this body of law to spicy foods generally, or to Mexican food or salsa specifically, the court concludes that the logic of parallel cases applies here. As Los Tacos argues, Mexican food, and more specifically salsa, is often spicy. And in fact, that's what I want, right? I want the taco place to have salsa that, like, yeah. Ian, what's the warning on the bottle that you just had? The last dab. Doesn't actually. Oh, I guess you could take this as a warning. It says that the spice level is 11 out of 10. Welcome to the experience, Spice Lords, the most extreme version of the last dab sauce we've ever made. Okay, so that's I guess that's that. Everyone makes mistakes. I don't think. Does this count as a warning? 100% vegan, only cruel to humans. I mean, that might be so. In fact, when it comes to salsa, the spice is often the point. Generally speaking, a food purveyor cannot be negligent or liable for negligence under New York law for injuries resulting from an idiosyncratic characteristic of the consumer, so long as the purveyor's products fall within the norm for products of their nature. For example, under New York law, there's certainly no duty to serve coffee so that no harm will come to a user no matter what the circumstances of its use. I.e., if you imagine the world's dumbest consumer, right? You imagine somebody who gets a coffee, and what do? They immediately snort the coffee, like right up into their nostrils. That's not going to make out liability for if the coffee is too hot to be snorted into your nostrils, right? Because, yeah. Similarly, the court concludes that where there's evidence that Los Tacos salsa bar was abnormally spicy as compared to other salsas or Mexican food, there's no duty to warn a consumer of the spice-associated risks that come with consuming salsa. Further, Mr. Mans' evidence is entirely lacking in this regard. The only evidence he puts forward is his personal testimony regarding injuries suffered from consuming the salsa. He provides no evidence of anyone else having suffered an injury from or complained about consuming Los Tacos salsa. He provides no expert evidence to demonstrate, for example, that the spice levels were higher than that of similar restaurants. I mean, he could have had it capsaicin tested, right? Can you link where to buy that sauce? You mean my sauce or the Hot Ones sauce? Those are different things, right? He also provides no evidence whatsoever as to what the reasonable standard of care for spicy food. Even if he established a standard of care, he admits that he never asked an employee about the spice of the salsa and that he never sampled the salsa before placing a significant helping on each of his tacos. Like, when I get a new hot sauce, I try a wee little bit. So this is my hot sauce. I have a friend who came over, and this friend is a spice wuss. And my friend was like, I want to try your salsa. And I was like, or I want to try your hot sauce. And I set it down. Jolene, if you just do a Google search, you'll find it. Just do a search for the Hot Ones hot sauces, and you'll find them. They're online. But my friend, I set the bottle down. I was going to get a thing. And she's like, oh, it's okay. I've got a spoon. And I was like, oh, honey, no. You are not trying this with a spoon. And so instead, I got her to try it with a skewer. So we dipped the skewer in the hot sauce and she tasted it. And she immediately went, because it's very, very spicy. And that's why I didn't let her take a spoonful of it, right? But if she'd taken a spoonful of it, she would have acknowledged that that was her damn fault. Hey, did Runkle get his haircut? Looks trimmed. I did, actually. So, yeah. The skewer was enough to cause her some serious problems. So the only evidence regarding the level of spice at the Los Tacos in the record, unauthenticated online review photos indicating that the salsa bar used to indicate spice levels on the various salsa, demonstrates that the red salsa, with which he had no issue, was marked spicy, while the green salsa was marked medium. I actually suspect that this person might actually have a like an allergy to tomatillos or something, right? So, without any admissible evidence as to reasonable care or spice level, no jury could conclude that Los Tacos had a duty to warn Mr. Mans of the inherent spice present in the salsa. Yeah, I mean, the other claims are basically the same thing, you know, basically, he fails in this claim because salsa is spicy, and that is exactly what he ordered. Yeah. All right, let's cover super chats. Suzanne D says, hoping for a pain-free Runkle Day. No, we're not there. But, I mean, the hot sauce has helped by causing different pain. Contribution to the Pro Bono Fund from the Replay crew. Thank you so much. Suzanne D, thank you for becoming a member. Much appreciated. Girl named Joey. Great show, you and Peter. Really interesting. Peter is fantastic. The Phoenix Paw. Good evening from Sweden at 2:30 a.m. Good evening. It's me, Tony P. Thanks again. Hopefully you have something good to drink because I don't. Innocent Gun, pretty good. Suzanne D, have a drink and did you get some rest? A little rest. Patricia 1958, thank you so much. Sir Alexander Full, would roll of pennies be a band of metal? But there's no finger rings, so that doesn't do that. Meme Empress says, my favorite microplastic, metal. Ann Janeski, thank you so much. Random unbreaded commenter, I punch harder with cloth hand wraps, law's stupid. You're not wrong. Amanda Florentin, thank you so much. Yesia Makaran, I'm sorry, that is awful on my part. Thank you so much. Meme Empress, pretty sure a hockey glove hurts more than a 3D printed brass knuckles. Just asked B. Tachuk after Gordy or Goody slapped him. Yeah, I mean, hockey gloves are big, heavy things. Random unbreaded commenter, don't mention Bronca on WGL. They don't have, or they have long time beef. I don't see why it would come up. Laura J. Riker, Afroman said the jury looked at the verdict like he was smelling a fart. Funny you said the same thing. Great boyish Marhanes thick alike. Am I right? You're not wrong. Jeannie 1, this judge was on Pike County Massacre trial. Oh, interesting. Laura J. Riker, watching much longer. You're worth every minute. Thank you so much. Random unbreaded commenter, response to judge should be, I believe corrupt judges should be removed from the bench via guillotine. Do you want to ask that question again? Nope. Random unbreaded says, I can think of hearing about Maya's Kurt stream going, hey, she's 18. It's legal now. Hey, Maya Holla, the ick. This poor girl's been through enough. Yeah, that was not my favorite Kurt moment. I like Kurt. Kurt's I like Kurt overall, but that was not a great moment. And I quite frankly think Kurt regrets it. So, which is progress. That is helpful when everybody makes mistakes. It's the name of my hot sauce. And Hunk Banana No, thank you for the 10 gifted memberships. Yes, I'm a Karen. Yes, I am a Karen. Fair. Okay, I see it. That was a Kurt defining moment. It was a dumb moment from Kurt, but he learned from it, I believe. So Honk Banana No, thank you for the 10 gifted memberships. Musings of Apathy. Is this the lawyer that Rob interviewed after the finding of liability? I believe that was the other one. Crazy Cat Queen. Will those allegations prevent Greg from being paid, though? Maybe. That's up in the air. Sandy, thank you for the 10 gifted memberships. The Jet JJ, I'm late, but here for the goal. Thank you. Masterful Melon. Woot. Number 15 sword, meat tree. Tree meat ground. Yes. Mega's autistic. Has Zora forgiven you yet? Yes, because the actual Mrs. Runkle came home. For the people who don't understand what that is a reference to, Mrs. Runkle called to say, I'm at the grocery store. What should I pick up? And because I was juggling other things, I put Mrs. Runkle on speakerphone. And when I put Mrs. Runkle on speakerphone, the Zora ran from another floor of the house. She ran right up and then stopped and was like, where is Mrs. Runkle? Where is Mrs. Runkle? And then she figured out that there was no Mrs. Runkle. It was just on the phone. And she was like, she made a face at me like, well, fuck you, buddy. So, yeah. All right. What do you call it? Josh Glover says, Pantsless lawyer, literally a Law and Order plot. I have not watched Law and Order, so yeah. Pants are overrated. Yes, but you have to wear them at times. And Any relation to Corey's pantsless friend Bryce? God, I hope not. Creek native girl. I'm late. Pantsless lawyer. We've covered that now. Joy W. Can. I don't know what the big deal is about no pants on Zoom. Drunk might be a problem. The big deal is that he apparently showed his dong. Like, when the dong is out, that's a problem. Crystal Dagger, enjoy a beer, Ian. Thank you. Mysterica Claus, that member was not managed. Do not manage your member on a live stream. Salty Owl Almanac, Scoopta, good one with this filing. Yeah. Emily Arons, at a former workplace, an employee once came into the office with no pants on. He did have underwear. I believe the police escorted him out. Yeah, that's a good thing. Kelsey Metzen, just tuned in just in time for the pee-pee jokes. I sometimes am a child, so. The Southern Mom, the Maya update is sad. If true, it's awful that she's been through so many challenges. Thanks for all your coverage of everything. Yeah, and if it's not true, it's also sad. So it's sad either way. Honk Banana no, but his no pants finally grounds for ineffective assistance of counsel. It might be, yep. Michigan Farm Boy, your drink brand sounds like innocent, like all of your clients, and you like guns. You have to be able to make a tie in there somewhere. You're not wrong. None left. Flagging the judge is ethical. Good to know. Trakushin, loved your interview with the lawyer you know. Have fun in Chicago. I am not going to have fun in Chicago. Catherine Lynn Fraser, thank you for keeping our eyes on the defense. Thank you. Geekbutt says, is this lawyer's gone wild night? Haha. Yes. Tranquil moments of time. Thank you. Chelsea Rama. So what we've learned is that Germans can't handle it when it's hot or cold. Little World War II humor for you there. Thanks. I'll be here all week. I mean, there's not a lot of World War II humor that I'm like, okay, that's fine. That one I'll allow. Amanda Florentin, which hot sauces were the hottest? Yeah, it's the Hot Ones Last Dab. You can find that online. Yeah. Kimchi, the forensic homeopath. New York City has an absolutely abysmal taco scene. What are your thoughts on chiltepins? I've started growing them in my backyard. Can send you a tin if you like. Would love that, Kimchi. That would be awesome. Laura J. Riker, Mans was butthurt. he was in the worst way. Kimchi, the forensic homeopath, hot sauce. The hint is in the name. Yeah. Light Queen, thank you for the 20 gifted memberships. All right. That can I get a link to the story about the pantsless lawyer? I've got a couple of VTuber friends that Winnie the Pooh their characters that would find this story hilarious. D Starfire, if you send me an email, I can send you the documents. So I don't have a good link, but I do have the documents. So yeah. Yeah. All right. There's also a footnote. Maybe I should show you the footnote before we go. Let's do the footnote. Footnote, the court notes that while Rule 11 sanctions may be appropriate as to Mr. Mans, given the apparently frivolous nature of this complaint, it does not consider such sanctions at this time, i.e. lost tacos. Do you want sanctions? Bring the sanctions if you want the sanctions. So, yeah. All right, this is a shorter episode. We've gone for 2.5 hours. Now, I'm going to let you go because I got to call somebody back. Otherwise, I would cover maybe some more stuff, but this was all the stuff I really wanted to cover because this is the most hilarious stuff, especially the Winnie the Pooh lawyer that I laughed until I cried. So, hot sauce versus weapons. Which do you have more of in sight? Hot sauce, but it's not even close. It's hot sauce. So, yeah. Rats, I left this on for the dogs while I was gone and only caught the end. You can start over at the beginning, Gracie Lou. That is just fine. When will we see you again? Monday, unless something comes up. If something comes up that I want to cover on a stream, we might do a stream midway through the week. But for right now, it is Monday. All right. Good night, all. Thank you for joining me, and I will see you soon. So.